May I please, my lord?
Yes.
My lord, I beg to petition for listing of a motion matter tomorrow, my lord.
Okay.
Yeah, please, Lord. I beg to mention item number 12, Lordship, joint prayer, Lordship. In this case, the matter was referred to the mediator, Lordship. The first seat was only. The second series is fixed on 20, Lordship.
20.
12, Lordship.
Well,
Lordship, the learned mediator has informed us that they need at least 1 month time.
who is the mediator?
Mediator.
Mr. E. Kolita. Current counsel for the petitioner, Mr. K.M. Halloway. Current counsel for the respondents have submitted that the proceeding in the mediation process was held on
Lordship, on 6th, Lordship, and
6th of February 2026. Post of as the mediation process
next sitting is
in
fixed on
progress.
20, Lordship.
Mr. Uddal, and counsel for the parties have got listing of the case. After 1 month, is the case being on
25.
May I pray for listing of a motion matter tomorrow, your lordship?
Okay.
Motion
What is the
matter.
subject?
Lordship, this is your lordship tender notice is put to challenge. Deeply.
I please, your lordship. Lordship, I beg to mention an item for fresh listing, my lord.
Item number?
For fresh listing, my lord.
Okay.
On next Monday, my lord.
Motion.
Motion, my lord.
Yeah, lordship, listing for listing fresh motion matter, lordship, related to license of fair price shop.
Monday.
Monday, lordship. Supplementary list for motion, item 14.
May it please your lordship, this is a contractor on payment of contractor's bill matter. Opposite party. In this case, my lord,
In the name of... Yes.
formal work order, my lord, dated 21, page 14, my. Actually, in this case, the petitioner has completed 80% of the work, my lord, because to 20% he won't be able to work. He has filed representation before the concerned authority to not unable to work 20%. But since he has taken loan, my lord, so he won't be able to maintain his family, my lord. So he has filed representation to make a bill for
Where
payment
is the
of
standing
bill.
counsel? AFDC. Please ask him to present. We'll take out after some.
Yes, yes, my
15.
May I please, your lordship.
Lordship, the TMC authorities had called for a tender wherein there were 5 packages were being called for cleaning, distilling, and maintenance of major rivers around the Gauhati city. There were 5 packages. Out of this, I had participated in package number 4.
Package number 4.
4. Now, Lordship, before going to the documents, now what had happened is that on 28/1/26, the bid were opened, and the committee, tender evaluation committee, sat on 6/2/26. That is at page number 251. It starts from 249, and I'm just taking directly to the package number 4, which is at page number 251.
Yes.
Lordship, package number 4 So there were 4 bidders out there. I am GB Construction number 2. The rest of the 3 persons are there. Now, they have been rejected. And on next page, they have been rejected. All the other 3 has been rejected for not meeting the criteria of the bid documents, which are mentioned specifically 1.5, 1.6 of QI, that is qualification information, and 4.3G and 4.4B of the invitation to bid document.
What are those?
Those are at page 40, on page 40.
Yes. Page
41, 1.5, 41. Lordship has got it. Page 40. So these are the corresponding requirement of 4.3G. The following items are to be given for carrying out the essential works. So these are the things: excavator, DI van, all these vehicles must be with the contractor. Now, so these were the main criteria which were not fulfilled.
1.5.
1.5, 1.6. So these 2 criteria goes to the root of the tender, because this tender is regarding cleaning and distillation and maintenance
1.6 is what?
of the QI. QI means the qualification information.
One 1.6 is not a
1.6 talks about this
must not be stored.
stored where it
That
is.
will be after
But 1.5 is basically the vehicles out there.
because this is a consequence. 1.6.
1.6 would be more of a consequence, but 1.5 is basically where it will be stored. 1.5 are the vehicles. Now I had given
And what is 4.3Z?
4.3 is page number 26.
Four point three C.
G.
That is related to 1.5 only.
Yes, that is related to 1.5.
And what is the other one?
4.4 B.
A.
That is 27. BA. BA.
A. Subpara, some leeway is there. 4.4.BA. That is also related to 1.5 only.
Yes.
Subpara.
So, Lordship.
4.4.BA.
Availability.
Second para. A bidder should, however,
undertake their own studies and furnish with their bid a detailed work plan and methodology supported with layout, charts, drawings, and calculations detailed as stated in clause 4.31 above to facilitate the employer to review their proposals. The number, types, and capacities of each plant equipment shall be shown in the proposal.
there should be a proposal.
Now, the rejection that was did happen. If Lordship may be pleased to come to page number 247 for a moment. Lordship has got it.
Yes.
This is a letter after on 28/1/26 when the bid were open. We had written this letter. May I read, Lordship? With due regards and kind reference to the above, I, Sri Ganesh Roy Modi, proprietor of GB Construction would like to state that I have participated in the tender for the work as stated above and submitted our tender documents as per requirement of the bid notification as stated above and all its corrigendum. The technical bid of the said tender was opened on 28/1/26, and in the said tender portal, we have seen the following bidders besides us also participated in the tender. These are the tenders. We have gone through the tender documents submitted by the fellow tenderers and found that they have submitted their tenders with faulty, defective documents which are mentioned below. These are the specific things which we have mentioned. Ajit Bhattacharya, bid number such and such. He 247. He has submitted the vehicle documents of 3 parties from which he has taken the rental, but he has submitted the rental agreement with 2 parties, which is only for 14 numbers of dumpers, which is below the required numbers of dumpers for the package. Rental agreement of third party Ramesh Gupta has not been submitted. Number 2, Bhagneshwar Kolta, bid number such and such. He has submitted documentary evidence of only 1 vehicle, DI van such and such, which is not as per requirement of the tender requirement. Number 3, Partho Thakuria, Dhubojyoti Sharma, bid number such and such. Partho Thakuria has shown all the vehicles as own vehicles, but he has taken all the vehicles on rental for which he has submitted the rental agreements, which is a point of rejection for submitting wrong information. As per information received from other tenders which have participated in the package, cleaning, distilling, and maintenance of the Bhorlu River ISBT to Fatasil Junction, Partho Thakuria has submitted the same vehicles in this package, also which he has also participated, which is the point of rejection of tender. Dhubojyoti Sharma has shown rental agreement with Sky Enterprise dated 25 January 2024, whereas he has purchased the stamp paper dated 27/26, which is a wrong information. So we had given these things, and thereafter this tender committee had said, and this tender committee, Lordship may be pleased to come to page 252 for a moment. This was signed by 252. This was signed by the additional commissioner as well as the chief engineer. These were the two. This is the tender committee. Now what happened is that on 11th February, they uploaded this. They had uploaded this thing, which is at page number 253. Next page. They uploaded it, and as per uploading, this is the thing. The others are rejected. Mine is accepted. Now, what happened for reasons best known to them, which we are not privy to it, page number 254. This is the impugned minutes. May I read? As the committee received 2 complaints from bidder, Jitendra Salini, Madan Boro, Ajit Bhattacharya, Partho Thakuria, Saurav Burman, and Pawan Sharma, Partho Thakuria, and such and such dated 12/2. Accordingly, a review of the centralized tender evaluation committee was conveyed by wide letter dated such and such, chaired by the additional commissioner in presence of Sri Megha Hazarika, member of MIC Public Works, and other members as per Annexure A. The meeting was held on 13/2/26 at 11 a.m. in the office chamber of the additional commissioner GMC. The committee was apprised that the proper publication was done adequately via e-procurement. Assam tenders were adopted in adequate time of more than 21 days were given for bid preparation and submission. The meeting was convened to re-evaluate the technical bids of 4 packages for cleaning, distilling, and maintenance of major rivers as detailed below under the mitigation of the urban floods in Gauhati city under Gauhati Municipal Corporation for the year 25-26. The committee discussed the matter complaints in the detail and took the following decision. It does not talk about anything regarding what happened in the earlier meeting. That meeting, it just went for a whiff. Now, what it says, number 1, in continuation of the review of the standard bidding documents pertaining to the vehicles and the machineries, the committee revisited its earlier decision concerning clause number 1.5 and 1.6 of the QI and clauses 4.3G and 4.4B BA of the ITB. Upon detailed examination, it was observed that the disqualified bidder had submitted a self-declaration along with other additional documents in compliance with the said clauses. As there is no specific clause or stipulation expressly barring consideration of the basis of a lease agreement alone, the submitted documents have been taken into consideration. With regard to non-disclosure of commitments of ongoing projects by PS Enterprise, this I am skipping because this has nothing to do with me. Among the bidders, only GB Construction, that is me, has submitted Annexure A self-undertaking for statutory taxes. in response to the entire NIT. However, the successful bidder shall be required to submit the same in original at the time of execution of the contract agreement. The committee decided that the following documents shall be required to be submitted after the issuance of the LOA and signing. Lease agreement for the vehicles and machineries. In case the bidders undertakes to lease the same. In case of own vehicles and machineries, valid proof of ownership shall be produced. Now, this is a tender where it's distillation and everything is that. That means you do one thing, you participate. Later on, you give me the vehicle details and vehicle part. Detailed methodology for execution of the work may be modified in consultation with the engineer in charge, taking into account the actual ground situation. The abstract of the committee review technical evaluation is recorded. This is the review thing wherein by which the other persons were made responsive, which is at page
Yes,
number
Mr.
2.
Vora.
And I've seen it, my lord. Because there is a complaint, my lord. Out of the complaint, the review meeting was done, and thereafter. this was-
Why this tender evaluation committee found few bits non-responsive due to 1.5,
No, this I have seen.
page 41.
Lordship.
And you said that following terms of contractor's equipment are essential. Essential.
My lord.
And if essential, then how can you dilute secondly? How can
So
you
there-
review?
Lordship will
If
examine
that
this and whether.
regularity and consistency and sanctity of the process is
My lord.
somehow later on you dilute.
Because the.
If this
subsequent-
dilution is to be made, then this dilution has to be made in the NIT itself.
Nice. That's lordship. absolutely correct.
Other bidders who might
No
not
bidders
have
would have
all those
participated.
equipments, then after agreement, they could place documents. Then it is like Ramana Daram Seti.
Lordship. Right. Because of the
Alright.
complaint, this review petition was, meeting
Alright.
was done, and thereafter this.
If
things
you
have-
take a decision, you have to stick by that decision.
Lord,
Or you cancel the process.
That is one of another.
That is a
But
different
this,
issue.
this is
But
in
you
public.
have reviewed again.
This is in public interest matter because coming floods are getting, rainy seasons are coming up. That's,
So what do you suggest?
so we'll examine
We
the,
have early option.
let's we'll examine, well, I will, I'll produce the records. my lord.
R.J. Das, Land Council for the petition.
Lordship, I'm extremely sorry. Just one last point. The last review meeting, 13 meeting, it was only signed by the additional commissioner. It was not the chief engineer also did not sign. That is reflected in page 256. That is also, I just forgot to. And the financial bid has been opened. That has been informed just before.
Have you made those bidders party?
Yes, yes, I have made all the 3 4.
Yes, Mr. Bora, can you serve those bidders through you?
No, let him take
Because
steps, my lord.
rainy season is coming. The bid work is cleaning of
He
major
takes-
river
my lord,
channels.
My lord, he need to take steps on the, all the
He'll
responsible.
take steps, but that will take time.
He can also go for dusty also.
Dusty will do. Mr. S. Bora.
This, my lord, one thing is, my lord, there's only for package number 4, my lord. Please repeating.
Current standing cost. You are also DDD?
Lordship,
Standing
I appear
cost
for
is
response.
DDD
1 to 5.
and
1 to 5.
CMC. For the respondent number 1 to 5. Where is the tender notice page?
Page page 15
Five.
it starts.
Initiating
It's-
an open competitive bidding process with the publication of an invitation for bid IFB on 13/30/12/2025. The respondent Gauhati Municipal Corporation, Gauhati, GMC. Invited bids for eligible bidders for cleaning, e-silting and maintenance of major river channels within bracket as packaged under mitigation of urban flood in Guwahati city under GMC for the year 2026 in 5 number of packages. Most of page 19 of us. The present petition pertains to package number 4, which is quote unquote cleaning, desilting and maintenance of Lakhimi Jan from Bhetapara Golden Path to Dokhin Pump House, quote unquote contract work for short. Full stop. In response to the IFB, 4 number of bidders, including the petitioner, submitted their bids online through the portal assamtenders.gov.in. The technical bids were opened when
28/1/26.
28/1/2026. On 6/2/2026, the tender evaluation committee consisting of the respondent number 3 and the respondent number 4 evaluated the 4 bids and therefore declared the bids of the respondent number 6, 7, and 8 as technically non-responsive. As the bids did not meet the qualification QI. What is QI?
Qualification information.
Criteria set forth in clause 1.5 and clause 1.6 of qualification information QI and clause 4.3 within bracket small g and clause 4. Read with clause 4.d and clause 4.4 within bracket capital B within bracket small a of the instruction to bidders ITB. Full stop. However, a committee named as Centralized Tender Evaluation Committee decided to hold a review meeting on 13/12/2026 to reevaluate the technical bids in respect of 4 packages, including the contract work under reference. Full stop. Revisiting the earlier decision of the Tender Evaluation Committee with regard to the aforesaid clauses, the Centralized Tender Evaluation Committee has observed that the disqualified has decided that the required documents mentioned in the aforesaid clauses can be submitted up also after issuance of letter of acceptance, LOA, and while signing the contract agreement, post of para. Mr. Das, learned counsel for the petitioner, has submitted that after evaluation of the bids in the meeting of the technical evaluation committee on 6/2/2026, thereby declaring the technical bids of the respondent number 6 and 6, 7, and 8 as technically non-responsive. The state decision cannot be reviewed and the tender clauses cannot be modified at a subsequent stage. So he has further submitted that the so-called centralized tender evaluation committee, only the respondent number 3 had signed the decision. Post of para Mr. Boral, understanding counsel, DDT and DMC appearing for the respondent number 1 to 5, has submitted that he would obtain instruction in the matter. Post of he has submitted that all the 5 packages are required to be are of seasonal importance, and the contract works are to be completed expeditiously as in view of the coming rainy season in Gauhati city. Post of para. Issue notice returnable on slides of the document. 9(3). As Mr. Bora, 1 to 5. By today, extra copy to him.
Lordship, date is given as 9th.
9.
Lordship, can it be
Steps.
anyway after 11, just 2 days after 12th or 13th?
No, it is Guwahati city. It is concerning all.
The-
Package is to be before rainy season.
I mean, just
Then
anything, it can be earlier also, because I'll be just out of station on 9th. That's the only. 9th
11th.
and
11th.
Huh?
11th.
11th.
11th, I'll return. That's it. Just 12th, maybe just 1 day. Just 1 day, Lordship. I'm just praying for that.
Everybody will suffer.
No,
Let it be on 6 minus 6. 6 no?
Everybody sitting inside
If
this
it's
courtroom
early-
will suffer,
if it is early.
myself included.
Lots will put,
No, and
fix it on
we are,
6.
we are, the present contractor are already doing this thing this year. It's already been.
You are the existing contractor.
Yes,
You are.
yes. That's why this part is being already been done.
The question is before rainy season,
This will be
everything.
done, my lord.
Yes,
Everything
yes.
is
But
taken.
I'm not for delay.
Let it be on 6, my lord.
I have no problem on
You
six.
take steps, you also take steps.
I also inform that.
Inform. Okay. As preferred, Dosti would compliance affidavit. By 5th. Huh? Get to the registry. So, para. The cross so and so are interrelated in nature. First of clause 4.5 requires the bidder to submit the items of equipments along with the technical bid as per clause 1.5. The same Thus, furnishing of details of such equipments are essential for carrying out the work. So, the clause 1.5 is also in reference to clause 4.3 and clause point EA of the IAB. So, once the bids of the technical bids of the respondent number participant bidders are declared non-responsive, subsequent revisit of the same tender clauses to reach an observation that the essential documents can also be submitted after issuance of the LOA and at the time of signing the contract agreement. Prima facie appears to be in violation of Article 14 as such relaxation of a clause has the effect of denying other anticipated bidders from participating in the competitive bidding, open competitive bidding. The dispute matter, the decision of the decision of the centralized tender evaluation dated 13/2026 NXRC shall in state.
In respect of package number 4, madam. In respect of package number 4, there are
In
5.
respect of package number 4 shall remain state till the broadly that after after evaluation of technical bids on 6/2026, the respondent MC authorities had published the tender summary reports as regards the receipt of one technically responsive bid from the petition and technically non-responsive bid of the respondent number 6, 7, and 8 on 11/2000. The respondent authority shall meet counter affidavit before the returnable.
16. Item.
This is also identical, minor. With respect of package number,
Task has become
Identical.
easier for me. Is in
the
respect
package
of
number 2 and 3.
Package number
2 and
2
3.
and 3. Your Lordship,
company
kindly
A,
see
2 and
page-
3
And the respondent will be
fiber
defined.
file over. Particular contract work number 1 or contract work number 2 করে দিন। Is there any appeal provision also?
There is, Malad, they have already, there is no, I don't find, Malad.
Page
60 is
46
there.
Page 46. Is there any appeal?
You've given one representation, Malad.
Where is the
No.
minute? Get a minute to like in the where is that first minute?
First minute is at page 123.
Was 20. Package number 2.
123, Package number 2 and 3, 124.
Package number 2 is 124. Three bidders. 2 bids technically responsive, 1 technically non-responsive.
They are
Clause
respond-
kita একে। And
their respondent number
package number,
3.
1 minute.
Put respondent number 5 and 6. 4, 5 and 6. 4, 5 and
Just prepared 2 repetition. Having 2 contract work in 1 repetition. Financial bid opening,
no.
then your competitor is also Bhavakanta Nath.
Obokanta, Madan Boro,
Ah.
Jitendra Saloy,
No,
and
otherwise, Bhavakanta Nath is also your competitor. Package 2.
package 2 years.
He is not made a party.
Where is Obokanta?
You have skipped him.
No, responsive bidders. He is responsive.
But he is in a competition.
Whoever
Afcon,
gets,
no,
we have
no,
no
no,
problem.
no.
with it.
Afcon Enterprise.
I'm-
Supreme Court has said. Afcon
what I'm
Enterprise,
trying to-
all the participant bidders should be made a party. Constitutional Court must ensure that all the participant bidders must be in
Particularly
the
there, Malati, here, what,
litigation.
hello, I am 1 minute, I take.
I have understood. It is not that I have not understood. You have made Madan Boro party, but you should have made as per the
Bhavakanta,
Afcon
because
infrastructure.
whoever
Bhavakanta,
can decide,
because
my lord.
he is in competition with you.
No, if financial bid, if he gets it,
No,
he
no,
gets
no,
it.
that is not the case.
I'll make him.
Because if Bhavakanto is made a party, then he could have pointed out your deficits.
Obokanta, my lord.
No, no,
He
that is a
responds-
law.
I'll-
I'm not
I'll-
saying from
I-
my case,
I'll
Mr.
stop
Das.
this. I understand that. but-
And you are clubbing 2 contract works in 1 repetition.
Because one petition,
Cannot be. These are different causes of action. Not common cause of action, different participants. Madan Boro is not in package.
in package 2, he is there.
Not in
And-
3.
And in package 3 also.
3
he is
was there.
He's
Then
also-
somebody
he's
else,
there.
Jitendra Halan.
He is there, madam.
This is not a way. Very good. Silicon. Package number 2 তে থাকো। Tender evaluation. T bids, huh? T bids, package number 2. So stop after evaluation, comma, the tender evaluation committee declared.
Page 120.
I am looking at it. 2 technical bids of 2 bidders as responsive. And 1 technical bid, and the technical bid of the respondent of 5 as non-responsive. Full stop. In package number 3, 4 bidders had participated, and the tender evaluation committee, after evaluation, comma, declared had declared the technical bid of the petitioner as the only responsive bid, while declaring the technical bids of the respondent number 4, 5, and 6 as non-responsive. Right? Okay. So, case number
2 and 3, my lord.
package 3.
Come on, sixth. Timing method, item 14.
In this case, without NIT. In all those methods, in a similar, I don't know whether this is being referred to as vigilance or not. In vigilance case and as well as enforcement director's case is pending, lordship. Those, this MD is being dismissed, lordship. The MD who issued the order. In many cases, lordship, I don't know whether this is within that package or not, that list or not. Let me give 1 week time. I will take the instruction before issuance of notice, lordship. If lordship.
Yes, yes, my lord.
Okay.
I agree.
Yes, K. Devi. And with K. Devi. Okay. And Mr. E. Sharma, understanding after some fisheries development AFDC Limited, a fishery department and so
Development Corporation.
for all the respondents,
All of them.
the petitioner has stated that he was awarded a contract work is 30. Excavation of pool number 1, bracket first half portion, bracket close at Captiville in the district of Karimganj, case number 13A. And as per the letter of acceptance dated 9/2/2000, the approximate value of the contract work would be 17,25,584. The petitioner has contended that he had executed 80% within bracket approx of the work, and due to financial hardship, he could not proceed to execute the remaining part of the contract work. The petitioner has further mentioned that despite representation, the respondent authority, the AFDC,
At this stage, the pension may be disposed of, my.
no, we don't, in this code, we don't, this code does not dispose of with
No,
petition.
he,
No,
that's how he.
yes, yes, he's right.
Normally, this code does not. Because that will give back to another litigation.
Actually, he is right. Is
Better to
keep it.
Yes, yes, my.
decide here.
Yeah, yeah.
Let him fit, my. Because he
No, no,
submits.
no, I'm not. Let me find out whether it's a
Yes.
fit case for issuance of notice or not.
Whether
Okay.
a case is pending in ED or vigilance.
Emperor.
But don't interrupt while taking
sorry.
dictation.
No, he insists me to submit.
Huh? Representation, the amount entitled to the petition. Has
Go on,
not
I
yet
will.
been
Puneban,
Sorry.
you know.
Mr. P. Direct counsel, standing counsel, fisheries and trade, paying for the response, submit that
It took it.
the contract work was perhaps without any bidding process. And there are certain cases which have been handed over to the vigilance department or investigation. He has sought a week's time to obtain further instruction and matter released as sought for by Mr. Sharma case on.
Let them, my lord, a date may be fixed. Next week, 25. 2.
Complex,
Yeah,
highly obvious.
Daily list for admission. Item number 1.
1 minute. You represent all the respondents?
Lordship.
All the respondents?
Two, three, four, five. Lordship one, the government advocate represents.
Okay.
May I
Yes,
please-
what
may I
is your
please-
case?
Chief, my lord, here in this case, they have filed, respondent number 3 has filed an affidavit.
No, that affidavit will come later on. What is your case?
My case is there was a scheme of
Scheme, what
Yes,
is the scheme?
NHMNA, my lord,
Where is that scheme?
Annexure 1, my lord, that
Annexer 1, page,
page, my lord, page 25 to 27.
25 to 27. So there is work order.
Yes,
Work
Okay.
order for establishment of
Scheme of-
small nursery. Let me read. Comprehensive care of time. Different. Nursery, okay.
basically this,
Nursery.
Work
You
order has
continue with
been-
the document first.
my lord. Basically, this work order has been enlisted to me, my lord, on the basis of a scheme called, my lord, NHMNH, which means that this scheme basically main object is to implement and achieve overall development in the horticulture department, my lord, including, my lord,
Where is the scheme?
Eastern State.
Scheme
my
is
lord.
available somewhere.
No, my lord.
Not
Yes.
available.
Now,
Then what did you do?
accordingly, my lord, I have executed the work, my lord. So, my lord, upon completion, my lord, there was a verification that has been
Where is
conducted by the.
photograph? Photograph
Yes, my lord.
of your nursery?
Now, my lord, affidavit in reply, my lord, I've incorporated.
Photograph?
Yes.
Let us see photograph. This is verified by them or it is somebody else's nursery?
This was the photograph that has been
Huh?
taken by the petitioner, my lord.
Photograph. 1 minute.
And there are some photograph, my lord, which those, my lord,
Okay, then go proceed from further from page
Now-
27. Page 27.
yes, my lord.
What is annexer 2?
Annexure 2, my lord, is the consolidated statements regarding the work which I have undertaken, my lord. Now,
Okay,
therefore, my lord,
1 minute.
after completion, my lord, all those,
No, please take me to the document first.
yes, my lord.
Let us flip the pages. Page 29,
Yes, my lord.
30. What is 30? Annexer 3.
Page 30 is the, my lord,
Yeah.
bank account, my lord. Yes.
Then
Then-
these are page 33 onwards.
But 33 onwards are the, my lord, those,
Evidence of
Yes, memo,
your
evidence.
expenditure,
yes, my lord.
tax
Absolutely.
invoices.
Now then report
Then
will come.
up to what page?
Page till
This
page
annexer 4 is up to
94,
what page?
94 are the expenditure.
94. 94. Okay. And what is 95?
95 is the, my lord, the verification report, my lord.
Report.
Yes, that has been, my lord.
We
Conducted, my lord.
officers have visited the and found.
My- 97 will be relevant, my lord. Page 97. In my case.
Then 98.
98 is the, my lord, letter issued by the respondent
I
number
have
three.
the honor to state it as per provisions.
That has been endorsed
Oh, Mr. has
and recommended for dispersal, my lord.
submitted vouchers actually. And what is the next 7?
Annexure 7, my lord, I have obtained RTA application, my
Ah.
lord,
For what?
regarding
Information? For what kind of information?
all the details why this scheme could not, my lord, all those documents which has been submitted. Then after procuring all the documents which I've submitted, my lord, then
Is there
immediately
anything
I
to be
turned
looked
up.
into? Is there anything to be looked into?
My lord, not
Annexure,
relevant,
nothing.
maybe.
Nothing. Then Annexure 9.
Then that was the submission.
Annexure
Annexure
9,
8,
page
9, 10
107.
are the application which I submitted, my,
107.
starting from 105, my lord.
105.
Yes, my lord.
Yes.
My lord, can I kindly for a second, my lord, page 97, can I
What is
kindly,
your prayer here?
my lord, to release the subsidy amount, my lord, in terms of the recommendation annexure 6, my lord.
Ah, okay.
So, my lord, can I just kindly just take for, I can 1 minute, my lord, 97, my lord. Because that is the basic report that will be relevant.
What have
here
I
in this
seen?
case.
Marked already marked.
My lord, they have accepted it. Now they are, by filing this affidavit, they said, my lord,
Let us see.
para, my lord, kindly see report annexure 1, my lord. Here, annexure,
This
my
is
lord.
by respondent number?
Respondent number 3, my lord.
Who is respondent?
Director, my lord.
Director.
Yes.
Direct.
Page 117, my lord.
100?
117.
No, no.
Running page, my lord. Internal page, my lord, page 6 of the affidavit in opposition.
70. Huh.
My lord, here,
Huh.
they want to say that, my lord, by issuing that letter, my lord, that my nursery was at establishment stage, first of all. Secondly, they point out that back ended, the fund already back ended. Fund is no more available, meaning thereby, what I understood,
Page 117.
117.
This is in reference to a report,
Report.
site inspection report. 31/12/2021.
That,
Photographs enclosed.
and photograph
It says.
seems does not
It
complete.
says neither positive nor negative. Photographs enclosed. Yes.
Thirdly, they said that those photographs which were incorporated in the report.
Now what is 116?
In this report, my lord,
116.
118,
116.
116. And next are two could my lord.
You took me to 117.
One, yes.
So 116 is the page just before it.
116 is the my lord code. Next page, my lord. Next page.
116 should be the preceding page.
116 is the my lord. Bit of part.
21/12/2021 letter.
Yes, 21/12, that is, I'm showing my lord. 21/12. 117, I'm submitting my lord.
Lordship, this is the joint verification report.
Where is
The
the report?
Lordship report is, Lordship, down it is written, Lordship, mother block of fruit plan. Lordship, at least 2 bighas will be required. 2 bighas
You are
of land.
requested to submit an up-to-date status report.
Lordship,
Right?
Lordship.
Of the nursery with
Yes.
photographs.
Photographs
Next letter
and
117.
Yes.
We have seen 2 photographs. Right? Where is the
Yes.
report?
Lordship, if comes to paragraph 5 of my affidavit in opposition, Lordship. That the respondent number 5, by its letter dated 3/1/2022, submitted a up-to-date status report of the small nursery of the petitioner to the respondent number 4, that is the Director of Horticulture, Lordship, after his personal visit to the said nursery, namely All Amin Nursery, and the same has been forwarded to the
Where is
deponent
that?
by the respondent
Where is the
number 4.
document?
Lordship,
Report,
the
report.
down that they have written, mother block, Lordship, mother block of fruits
no.
and at least 2 bighas.
116, director has directed.
Lordship, it was a field verification, Lordship. So, yes,
Where from?
they have gone
Where?
to the site, Lordship.
Smora.
Lordship, down,
Page 116.
Lordship.
But it is written. Last line. Therefore, you are requested to submit a up-to-date status report of the nursery with photographs signed by you prior to payment of the submitted bill with the following information. 1, 2, 3, 4, 5.
Lordship,
Right?
Lordship, Lordship.
Right.
Yes,
Then
yes.
next page, that is dated 21/12/2021. Next page.
It is after that.
117.
This is the
Wait,
report,
refer-
Lordship. 3/1/2021, January.
3/1,
This was
2021.
December.
So that is much earlier,
That status report, Lordship.
much earlier.
Yes, Lordship, January.
Then where is the report?
Lordship, subject, it is given up to date. This is from the district agricultural officer to the director, Lordship. This is the first, this precedes the previous page, Lordship.
Now, in your paragraph 5, you said up-to-date status, submitted an up-to-date status report. Now,
Lordship, with reference to the subject cited above, I have the honor to submit herewith the up-to-date status report of small nursery of Nurul Alam Borbhuya of Ujangram, Kachar, as reported by the concerned agricultural development officer visiting the site on 31/12/2021. Besides, 2 number of photographs are also enclosed herewith.
that report is not part of the record.
Lordship.
That is what I am asking.
Yes, yes, Lordship, I can place that.
If these are,
Photographs.
Mr. Muri, these are controverted. Thereafter, nothing remains for this court.
My lord, just one, if I could
Lordship,
indicate.
he has filed the affidavit in reply in 2026 January. The case was of 2022, Lordship. And now he says that
Now,
here's
I understood.
certain pictures, Lordship. And the whole project was back-ended. Lordship, back-ended is he has to complete the project and then we will provide with the subsidy. Lordship, if he has completed the project on time, it was on the part of the beneficiary to inform the authority that he has complete
Back-ended means.
after the project is complete. And in the Lordship, and in the status verification report, it was given that the nursery was in the establishment stage.
So once it is controverted, we have nothing to decide in a read petition, read jurisdiction.
My lord, may I just indicate one thing, my lord? Annexure 1 in the affidavit, my lord. This was in the year 2021, my lord. Then, my lord, the date was 21/12/2021. Now, the projected report annexure 2, my lord, which was a field verification conducted by the district
So,
agriculture
Mr.
officer.
Mori, what is the scope and ambit of read jurisdiction?
Lordship, I can understand to that, but I'm just
Now,
indicating
if-
one
if
thing, my
They
lord.
do not admit, then where is the question of going into disputed questions of fact?
My lord, just see, my lord, what the letter says, my lord. His letter, my lord, report was 3/1/2021, my lord.
That was
No,
earlier.
No, my, if I
The
could
fiscal-
understood correctly, my lord,
fiscal
just,
year is also over,
lordship, just there's appears some things, my lord, report. Order
I
was,
said.
letter was issued in the month of December.
Either positive or negative, that is page 117. Simply, it annexed a document. Two photographs, right? Two photographs. Oh, these photographs are.
This annexure 2, my lord. It was in the January, my lord. Before,
No, these
before even
photographs.
letter seems backdated, my lord. The report seems.
Leave aside 117,
118, my lord.
118.
It
That
was
is
in the
of-
month of January.
That is in reference to perhaps page 116. Because dates are same. Date is same. 21/12/2000.
Reference to letter dated 21/12/2021. That report has been submitted, my lord, on January, my lord. Even prior to issuing the letter 21/12.
No, Lordship, here is a typographical mistake. I have clarified in paragraph 5, Lordship. The letter date had been 3/1/2022. That he was trying to say, Lordship.
Yes.
Because in paragraph 5, Lordship, I have written
Ah.
while letter dated 2022. There is a typographical mistake, Lordship.
So where is the
But in
report?
the signature, Lordship, it is, yes, the report is not annexed, Lordship. That is true, but in the signature, Lordship, it's 2000, annexed, Lordship, it's 22.
Visiting 31/12/2021.
22, the undersign is 2022, Lordship.
Submit herewith an
3/1.
up-to-date status report. This is on 20/31/2020. And what is the scheme about, Ms. Bora?
For construction of nursery, Lordship, it is like for one fiscal year, Lordship. And his was from 18 to
what-
19, the scheme was. His work order was of 2019, Lordship.
Now,
The money sanction HMNEH. What is the name of the scheme? The money sanction and HMNEH.
Horticulture Mission for Northeastern Himalayan States, Lordship.
What is the objective of the scheme? The construction. Or the date of which- No, it bills. What is it? Release of some- Come to page 27. There is a condition. Final release of subsidy will be subject to receipt of satisfactory report from joint inspection team only.
Absolutely, my lord.
Lordship.
Now, we don't have any joint inspection report which
My-
is satisfactory. Rather, it has pointed out 5 deficiencies.
Now, my lord,
Mr.
yes,
Page 113, mother block, irrigation facility, protected structure, garden implements, skilled manpower. We don't know the scheme, ABCD of the scheme. Right? Nobody has placed it. And how can we judge?
now,
What are the conditions? You have to stand on your own feet.
actually, lordship, this, my lord, has, my lord, a scheme is, work order was in, of the year 2018 to 19 scheme.
We don't know, mister.
Now, yes, my lord.
Nobody places in the scheme what is the requirement to get subsidy. No, court is not aware. And there is unsatisfactory report after joint inspection, meaning thereby your claim for subsidy has been negated. Now, whether you have completed all these photographs, right, in the affidavit in reply, as the position as on 21/12/2021 is evident from the photographs.
Now, what
There
I-
is nothing.
what I indicate, my lord, if, my lord, it is incumbent upon the respondent to conduct those verification, my lord. And admittedly, at the time of verification, as I.
We don't know the scheme, sir.
Yes,
Neither you have placed that this is the condition that after 1 year that they have to visit. It is not nothing you have said. After 5 years, if you have completed the nursery, whether you are entitled for the subsidy. These are all disputed questions now.
considering the fact that, my lord, it takes, I have implemented within the time, they have recommended, my lord.
We don't know. We don't know
This
the
is the
scheme
PR.
itself. It's except we know HMNEH. Nobody speaks about the scheme. Everybody says as if court knows everything. HMNEH. Everybody says about that. We don't know ABCD of the scheme. When a person can be eligible for subsidy, nobody knows. We have to find out. Now we are trying to find out ourselves.
These are off-seasonal, my lord.
You keep it in your mind. Don't translate into the writ petition. With so many deficiencies pointed out, how can we decide? Muri,
Yes, if
with so many deficiencies pointed out,
that is what, I'm replying, my lord, with due respect to that respect, my lord. If the work is of seasonal, my lord, for seasonal, maximum 1 year, financial year. Then if they further, my lord, after lapse of so many years, if they verify nothing remain, my lord, what will find, my lord? It was only in the year 2021 they are again further investigating into the matter and nothing found. This report says what will remain, my lord? Because these crops, these are agricultural products. It will not remain for long together years, my lord.
Mr. Few say this is nursery, not cultivation. Right?
Yes.
Nursery and cultivation is different. You sought subsidy for nursery,
Nursery, my
not
lord.
for rice cultivation,
No, my lord.
nor for any other seasonal cultivation. Right? That's submission. Now, that's seasonal.
is not in conformity with what he had intended. Nursery is different.
Immediately dispatch, my lord, those are disposed of, my lord, because cannot keep for long year, my lord. So whatever nursery we have cultivated, that has to be disposed of, my lord. Otherwise, lord.
Bora, come to page 98.
His lordship.
Page 98. This is the same man. Page 98 of the repetition.
Lordship 98.
Same officer. Have you addressed this annexer? In your affidavit?
No, lordship.
Then he has clearly said production stage. This is related to paragraph. Which paragraph of the repetition? Muri,
Yes, my lord.
this is related to which paragraph of the repetition?
Para, my lord. Para 12, my lord.
No, this is paragraph 12.
8 and 9 paragraph may be relevant.
Very silent.
And
Your affidavit is silent on annexer 6 page. Same officer.
In fact, lordship, I was thinking about that in the work order, a paragraph is there. Further, you are asked to prepare a detailed project report in consultation with the concerned technical experts of the department and submit the same along with bills, vouchers, relevant document, completion report, bank account details for on-one submission for release of subsidy. Final release of subsidy will be subject to the receipt of the satisfactory report from the joint inspection team.
No,
So I was
when you
thinking-
address this officer, he is
That is
just
what-
subordinate to director.
No, Chief District.
He has written page 98 letter
Not
on 17/3/2020,
Not Chief.
right? That's all relevant documents, right?
Not Chief.
On the basis of the work order, the above mentioned beneficiary has treated the same and submitted bills and other relevant documents for release of the subsidy admissible as per government norms. In view of the above, I would request you kindly to arrange release of government share if authorities satisfied. Right?
Lordship. Lordship, I may be given some time to verify this document. If this document is true, Lordship, then the subsidy has to be released to him, Lordship.
And subsequently, you cannot take a contrary stand. You have done it, and plus this is not there. Page 97. Your officers visited with the following team of officers have visited the project, right, bearing ID number so and so. Here, the unit is in the production stage
Establishment,
with effect from establishment stage and running in profit is in the production stage with effect from establishment. So establishment stage,
Okay, with effect from
Oh.
this, Lordship.
then signature of 3 officers,
Right.
1 senior scientist, right? So how can you deny this? I did not deny. You did not deny in your affidavit. Suddenly you realize when so let us have an up-to-date status. And at that point of time, we can see at least that, we can see at least from photograph, whatever it was devastated on page 119. At least his signboard is there.
Lordship, I may be allowed to clarify, Lordship. In 2 days, I'll submit a report, Lordship.
When did you submit your letters, all these documents? On what date? Sir,
My lord, before this
page annexer 2.
annexure 2, my lord, this added to
When did you submit?
that to my lord, I have no instruction, but from RTI only I could obtain, my lord. RTI I received on 3/3/2021, my lord.
When did you submit this? No idea.
No idea, my lord.
Miss Bora, you placed the scheme
Lordship.
and clarification. If it has been submitted immediately after
Completion.
allotment, after 4 months, 5 months, it is natural that you should have inspected him immediately thereafter. If everything has been submitted. And this letter, this inspection was carried out in August 2019,
21.
page 97.
Yes, sir.
And thereafter, in March 2020, the same officer wrote to the director, please release this amount. Now, how can you subsequently visit the place if it is the project itself scheme is limited by time? By 2 months, one may set up a nursery. 4 months, he submitted the bills. You inspected, team of officers. Okay. District officer wrote to the director, he is eligible. Now, how can you turn back without referring to your earlier report?
I'll take the
Some
instruction.
dispute is there, so it
Yes,
is
yes.
definitely for you to verify. or referring to this, we can dispose of this for the text
Yes, Lordship.
director.
Yes, yes.
No point keeping it pending. Again, you will come up with a prayer, give me 4 weeks. Art. Okay, I'll come back. Art. Mr. N.K. Moody. Loretta, for the petitioner. And Miss R. Bora. And it's standing us. Miss Sar Burka, managing government, number 1. And Miss R. Bora. And standing us, Agriculture Department, for the respondent. 225. Post of. In this retreat. Under article. The petition has entirely sought for a direction. The responding authority to release the due subsidy amount payable to the petition in terms of an work order dated 5/4/2009, issued in his favor by the respondent number 4. By the work order dated 5/4/2009. The work order dated 5/4/2000 was issued by the respondent number 4. For establishment of a small nursery with a further direction to complete the same within a time frame. The petitioner was informed that his name had been enlisted in the provisionally selected beneficiary list for project-based activities within bracket IE 7. Establishment of small nursery bracket close under HMNEH 2018-2019. So the petitioner was thereby told to start the construction stroke establishment of the small nursery within the time frame within bracket IE within 2 months bracket close on the date of receipt of the work order. Petitioner was asked to prepare a detailed project report (DPR) in consultation with the concerned ADO technical experts of the department, and to submit the same along with bills, vouchers, relevant documents, completion report, bank account details, etc. for onward submission for release of subsidy amount DBT within bracket. The petitioner was informed that the final release of subsidy would be subject to receipt of a satisfactory report from the joint inspection team only. So, it is a case of the petitioner that after his enlistment in the provisionally selected military list and issuance of the work order in his favor on 5/4/2019, the petitioner proceeded to undertake all the necessary works for establishment of a small nursery as per the advice stroke instruction and under supervision of the concerned departmental authorities. The petitioner stated that he had completed stroke executed the work order allotted in his favor strictly in adherence to the terms and conditions of the scheme named HMNEH 2018-2019. Poster. After completion, after establishment, the construction of the small archery, a verification team consisting of all district agriculture officer Kachar, the ADO, Arunachal Kachar, right? C, E and E, visited the small archery, the petition, which he has named as ALAMIN nursery, located at village Ujjain Gram Borkola, Silchar district. In the joint verification report, the team reported that the nursery or the petition was in the production stage, effect from the establishment stage. And the report and the officials had subscribed their seals and signatures. In the report, the joint verification report, which the petition has annexed as annexed a 5 to the verification. Post-op. Thereafter, the basis of the joint verification report, the respondent number 4, by his official data dated 17/8/2020, wrote to the respondent number 2, informing that on the basis of the work order dated 5/4/2009, the enlisted beneficiary, that is the petitioner, had completed the work of the nursery and submitted bills and stroke vouchers and other relevant documents for release of the subsidy amount as per the admissible as per the government norm. Informing so, the respondent 4 requested the respondent number 3 to make arrangement for release of the government's share if upon satisfaction. Post of. In the office letter dated 17/2024, Commander Respondent 4 had observed that the admissible subsidy amount would be 7.50 lakhs. Post of. When, despite submission of the joint verification report and the office letter dated 17/2000, the respondent authorities, more particularly the respondent number 3, did not release any subsidy amount to the petition. The petitioner has approached this by the representative para in the affidavit in opposition filed by the respondent number 3. A stand has been taken to the effect that a small nursery was sanctioned. Original letter dated 20/03/2019. Madam Bora, paragraph 4 of your affidavit. A small nursery was sanctioned. To the petition filed office sanction order dated 20/03/2019.
That we have not annexed, Lordship.
Post of the office sanction order dated 20/03/2000 has, however, not been made part of the affidavit in opposition. Post of. The respondent number 3 has stated that by an office letter dated 21/12/2000, he requested the respondent number 4 to submit an up-to-date status report of the nursery with photographs prior to payment of the bill, and the status report should contain information on the aspects mentioned herein. Post of. According to the respondent number 3, the respondent number 5 submitted an up-to-date status report of the nursery of the petitioner to the respondent number 4 on 3/1/2020 after a personal visit to the nursery, pointing out 5 deficiencies. Full stop. It is on the basis of the report submitted by the respondent number 5 on 3/1/2022 after personal visit. The respondent number 3 has taken a stand that the nursery of the petition was still in the is still in the establishment stage, and all the payments under the HMNH scheme it is the further contention the responsibility that payment under the HMNH scheme is completely back-ended. Full stop. Fine, Raghav. As the photograph submitted by the respondent number 5, which is report, had clearly indicated, as now, had clearly indicated that the nursery was not completed. Full stop. Para. Neither of the parties have brought, neither of the parties has brought the guidelines, terms and conditions of the scheme name HMNEH on record. Detail guideline. So stop. It is noticed that HMNEH scheme stands for Horticulture Mission for Northeast and Himalayan states. HM. And it is a sub-scheme under the centrally sponsored Mission for Integrated Development of Horticulture, in bracket MID. The objective of the HMNEH scheme is to achieve and implement It focuses on the holistic development of horticulture, including fruits, vegetables, spices, and flowers, specifically for the northeastern and Himalayan region. Full stop. It envisaged financial assistance in the form of subsidy to the farmers in the northeastern states and the Himalayan states. Para. From the joint verification report, within bracket annex of 5 to the report, which was stated to have been submitted by a team of officials after visit to the nursery, Alamin nursery of the petitioner at village Ujjo Ujjain Gram, district Kachar. The nursery was found to be in the production stage with effect from the establishment stage. Full stop. The report seemed to have been prepared in August 2019. That is near about after about 4 months from the work order dated 5/4/2019. Posto. The office letter dated 17/3/2020 of the respondent number 4 had endorsed the fact that the petitioner had completed the works of the nursery and submitted bills, stroke vouchers, and other relevant documents for release of the subsidy amount admissible as per the norms, government norms. From the office letter, from the contents of the office letter dated 17/3/2000, the respondent 4 appeared to have reached a satisfaction that the petitioner had completed his part of establishing a nursery as he had requested, as he, by the office letter dated 17/3/2020, had requested the respondent number 3 to make arrangement for release of the government's share, state government shares of the subsidy to the extent of rupees 7.5 lakh. Upon reaching a satisfaction from his end. Posto. Para. The respondent number 5 from the contents of from the stand taken in the affidavit in opposition of the respondent number 3, it transpires that on 31/12/2022, the respondent number 5 made a personal visit to the nursery of the petitioner and submitted a status report before the respondent number 4. The respondent number 4, upon receipt of the status report, had, in turn, forwarded the said report to the respondent number 3 by an office letter dated 3/1/2022. Posto. It is on the basis of the said status report prepared by the respondent number 5 after a personal visit to the nursery. The respondent number 3 has taken the stand in the counter affidavit that the nursery is still in the establishment, was still in the establishment stage. Posto. Para. From the when the when the proposal forwarded by the respondent number 4, to the response number 3. Provide office data dated 7/2020 is compared with the stand is compared with the stand taken by the response number 3. The affidavit, comma, the two it seems to have projected to different scenario. As part of this letter, as part of proposal contained in the office letter dated 17/2000, the nursery set up by the petitioner was complete, whereas was complete on that date, comma, was complete much before the said date, comma, 17/2000. So on the other hand, comma, on the other hand, comma, as per the affidavit in opposition of the respondent number 3, filed on 29/7/2000, the nursery of the petitioner was still in the establishment state. Para. The exercise of the extraordinary jurisdiction under Article 226 of the Constitution and it is to be exercised it is opposed to the very amplitude of the jurisdiction demands that it be exercised subject to certain limitation. It is settled that the High Court is not deprived of its to enter a writ petition under Article of the Constitution merely because in order to consider the right of the petitioner be granted the relief sought for questions of facts are to be determined. The writ petition under Article 6 of the Constitution, the High Court has jurisdiction to try issues both of facts and law. The process, the court has to consider as to what facts are in dispute and what facts are not in dispute. And such a stage comes after the exchange of the form of affidavits among the parties. A writ petition is decided ordinarily. A writ petition is ordinarily decided on the basis of affidavit. Full stop. When a writ petition raises disputed questions of fact and for determination of those, a fact-finding exercise is necessary and it may not be convenient to decide such disputes in a proceeding under Article 220 of the Constitution. And such a situation, the court may decline to try. In view of the contrary scenario projected through the office letter dated 17/3/2020. And stand taken in the affidavit, stand taken in the affidavit in opposition. Filed on so and so. Filed on.
28 June noche.
Para 29/7/2000. Comma, it is not expedient for the court to decide whether the petition had completed the nursery as per the work order dated 5/4/2019 and the guidelines, terms and conditions of the HMNH scheme to be eligible to receive subsidy amount to the extent of rupees 7.50 lakhs, as claimed. So, such a fact-finding exercise can only be undertaken by the respondent authorities in the agriculture department, government of Coastal. In view of the above, view of such obtaining facts situation, view of such obtaining facts, this court is of the view that it is the respondent number but because his stand is becoming doubtful, respondent number 3, he has not addressed the issue. He is hell-bent upon denying the relief to the petition. He ignored the earlier report. Respondent number 2, agriculture department, right? Commissioner Secretary.
Noche.
And taking note of the contrary stance taken by the respondent number 3 at different points of time. It is the respondent number 2 who shall undertake to undertake an exercise to reach a finding whether the petitioner had completed the nursery as per the work order dated so and so within the stipulated time frame under the HM so and so scheme to be eligible for receiving the subsidy amount from the government. Also, by conducting an inquiry. Also, the respondent number 2 shall afford an opportunity of hearing to the petitioner to submit all the supporting documents with regard to his claim for a subsidy amount under the H so and so scheme. So, respond number tell thereafter. On the basis of the materials on record and materials available in the departmental records and documents submitted by the petition shall determine whether the petitioner is eligible to receive the subsidy amount by the so and so scheme, and if the same is in affirmative, then what would be the subsidy amount petitioner is eligible to receive. The repeat, therefore, direct is goes on. The direct to complete the entire exercise in a period of 3 months from the date of certified order, date of submission, certified copy of this at his office by the pin. By passing a speaking order.
Complies, my lord.
By speaking order. The speaking order to be passed shall thereafter be communicated to the petitioner. Shall be communicated to the petitioner. Shall be immediately communicated to for information.
Obliged.
Yes.
Complies, my
You appear and claim, otherwise it is for
Yes, ma'am.
us. It is very difficult.
I can understand, my lord. If, my lord, otherwise, if convenient, my lord, minimize it too much.
No, they have to
Instead of
conduct an
three.
inquiry, Lordship.
Not possible. Election time, it should be four months. Okay, 4 months. Election time,
Again, I have to come safely.
you are sufficient. A petitioner, along with his authorized representative. So you will be sufficient.
Item 2.
Your Lordship, I'm appearing for the petitioner.
Yes. You are for the petitioner. And
Yes, Your Lordship.
Mr. Usami is for 2, 3,
2, 3, 4,
4,
5.
5.
Yes, sir. 2, 3, 4, and 5.
And Mr. Dutta,
For 6.
huh?
IRD.
IRD. Okay. One is a statutory authority, not required to be represented.
Let us proceed.
Yes.
Yes, Your Lordship. Your Lordship, if in the instant read petition, we have filed challenging the impugned award dated 31st of March 2023, passed by the Insurance Ombudsman Authority.
Which page? Page.
Your Lordship, the impugned award is in Annexure 11, page number 47.
Page 40.
7 of the read petition, Your Lordship. May it pleases Your Lordship, Before starting with the brief facts of the case, my co-counsel would like to hand over a written submission, Your Lordship, which we have prepared on the basis of the argument for today.
Please,
Please, Your Lordship.
narrate the facts.
Your
Please
Lordship,
narrate the background facts.
please, Your Lordship, please. Your Lordship, the petitioner is the registered owner of the truck which met with an accident. And Your Lordship, during the time
What
of,
is the met with an accident?
yes, Your Lordship, the truck that met with an accident.
When?
The accident took place on 26th of October 2022, Your Lordship.
Okay.
Your Lordship, during the time of the accident, the truck was duly insured with respondent number 2, that is Cholamandalam MS General Insurance Company Limited. And the copy of the insurance policy have been annexed in annexation number 4, page number 30, Your Lordship, in the writ petition.
So this vehicle had a public carrier permit,
Yes, Your Lordship.
certificate of fitness,
Indeed, Your Lordship.
valid insurance policy,
Indeed, Your Lordship.
right?
Indeed,
Okay.
Your Lordship. Your Lordship, and in
So
page
there was
number-
no deficiency.
No, Your Lordship.
And as regards roadworthiness, right?
Indeed. Your Lordship. Indeed,
Okay,
Your Lordship.
then
Your
it met
Lordship-
with an accident. What happened?
Yes, Your Lordship. Before the incident, Your Lordship, I would like to kindly see page number 30, Your Lordship. In the insurance policy, it has been specifically mentioned that the insurance policy is valid from 15th of February 2022 to 14th of February 2023 with an insured declared value of rupees 19th lakh 7,970. This is what it has
19
been
lakh,
mentioned.
where is that?
Your Lordship, in page number 30.
30. 19 lakh.
Yes, Your Lordship.
Basic OD. Basic OD.
Yes, Your Lordship.
Okay.
This is what it
Okay.
has been mentioned in the insurance policy, Your Lordship.
What was the total premium?
The amount which has been mentioned here, Your Lordship, is 19th lakh 7,970. Total value of the insurance policy, Your Lordship. Total value.
Yes.
Please, Your Lordship. So, Your Lordship, now coming to the brief facts of the incident, Your Lordship, on 26th of October 2022, the vehicle of the petitioner loaded with rice met with an accident while coming from
Is it a truck or what?
Yes, Your Lordship.
Huh?
This is a truck, Your Lordship.
Truck.
Yes, Your Lordship.
Where is that? The holder. Truck. Truck, open body truck.
Yes, Your Lordship.
Yes.
Your Lordship,
Yes,
the
please.
truck met with an accident while coming from Namti side towards Amguri town, Sivsagar, leading to extensive damages, Your Lordship. Your Lordship, right after the accident, a police case was registered and a police report dated 7th of December 2022, Annexure 5, page number 32 in the writ petition, and MVI report dated 29th of November 2022.
Just
and
a
it's-
minute. Just a
Yes, Your
minute.
Lordship.
Let me have a look at the police report.
Yes, Your Lordship.
So it was a collision between one trailer and a truck.
Yes, Your Lordship. The back side of the trailer and the front side of the truck.
So it was a truck which had collided from backside.
Your Lordship,
Hit the trailer, perhaps. Otherwise, front side, backside, it is quite indicative.
Your Lordship, in para number 4 of the police report only, it has been mentioned that during the course of inquiry, it is found that the accident was occurred due to congested road.
Let me read.
Please, Your Lordship.
Yes. Then what is the MVI report?
Your Lordship, in the MVI report, which is annexure number 6, page number 33, it has been specifically mentioned in point number 2 that the name of the driver is Ratul Borgohain, Your Lordship, which is the petitioner.
Yes.
So with these two official documents, it is clear that the petitioner is the driver during the time of the accident, Your Lordship. And Your Lordship, after this getting this official reports, the petitioner went to a service center, namely Messer Auto Exist Private Limited, to estimate the amount required to repair the damaged truck, Your Lordship. This is why he went to the service center, and the report presented by the service center is annexed as annexure 8, page number 36, Your Lordship, in the writ petition. Annexure 8, Your Lordship.
What is the name of the service center?
Messer Auto Axis Private Limited.
Where it is reflected? To X. Okay. When this was prepared?
Your Lordship, it was
Date.
I'll have to confirm the date with the petitioner, Your Lordship.
Yes. Then
Your Lordship, the estimated amount prepared by the service center is 19,96,148, Your Lordship. So this was the amount required for the repairing of the truck. After this, the petitioner went to the insurance company to and filed a claim to disburse the insurance claim amount, Your Lordship. And Your Lordship,
when did you lodge the claim?
21st of February 2023, Your Lordship, Annexure 10.
24th of
21st of February, yes, Your Lordship.
Which page?
One second, Your Lordship. Your Lordship, I'll have to confirm this. I'm not sure regarding the filing of the date, Your Lordship. May I proceed, Your Lordship? Please, Your Lordship.
Yes.
Your Lordship, after getting all the documents, the petitioner went to the insurance company to get the claim. Despite having valid documents, Your Lordship, the insurance company rejected the claim on the ground of alleged misrepresentation, Your Lordship. Your Lordship, the letter dated 10th of January 2023 passed by the insurance company has been annexed as annexure number 9, page number 42 in the writ petition, Your Lordship. Your Lordship, I'm referring to para number 2 of the annexure number 9, Your Lordship. We wish to state on careful perusal of the documents, it is evident that there has been a deliberate and willful misrepresentation on your part regarding the driver at the material time of accident. So they're claiming that there is a misrepresentation on the part of the driver, Your Lordship, during the time of the accident. And on this reason, the claim was rejected, Your Lordship. Now, Your Lordship, aggrieved by the letter passed by the insurance company, the petitioner filed a complaint in the Insurance Ombudsman Authority, which is a quasi-judicial body. And Your Lordship, after filing the complaint, it is an admitted fact that the respondent company has appointed an investigator, Your Lordship, after the petitioner filed a complaint. Now, Your Lordship, the investigator recorded an alleged video secretly without the consent of the petitioner in a state when the petitioner was highly intoxicated, Your Lordship. And Your Lordship, the respondent company are claiming that in that alleged video, the petitioner is saying that he was not the one driving the vehicle or the truck. Your Lordship, we do not know whether this contention is true or not because we have never received the video, nor the respondent company have annexed that video in the counter affidavit to this writ petition, Your Lordship. And Your Lordship, solely on the basis of that alleged video, the whole claim of the petitioner was repudiated and without giving a fair opportunity to the petitioner to even verify the alleged video, Your Lordship. So this is the brief facts of the case, Your Lordship.
Yes.
Please, Your Lordship. If Your Lordship is pleased with the brief facts of the case, may I start with the legal grounds of the writ petition, Your Lordship?
Why a writ petition? Instead of a complaint under Consumer Protection Act?
Because Your Lordship, the petitioner's fundamental right has been violated. The
What
video has
fundamental
been-
right?
The
What
state-
this is it is a matter of contract.
Your
Insurance
Lordship-
is a contract,
Your Lordship,
right?
Your Lordship,
Claims arising out of an insurance contract is contractual right.
please, Your
There is
Lordship.
no fundamental right is involved.
Please, Your Lordship. Your Lordship, I am relying upon a judgment passed by the Honorable Supreme Court in ABL International Limited versus ECGC Limited.
No, it is regarding insurance contract.
Yes, Your Lordship. Yes, Your Lordship. I have also supplied the judgment copy.
Yes.
Your Lordship, in this judgment, it has been categorically held that a writ petition is maintainable, even in contractual matters, against an insurance company where its action is arbitrary and unreasonable, Your Lordship.
Oh, here the question is not against the insurance company. It is against an order. They have a right to take a stand. They have the discretion to repudiate a claim.
Please, Your Lordship.
And thereafter matter is before a quasi-judicial authority, say, or insurance ombudsman, which is under a statutory
Your
scheme
Lordship.
of things.
Your Lordship.
And it is a decision.
Your Lordship.
The repudiation is under the carpet of the ombudsman decision.
Your Lordship.
It is a decision of the ombudsman, which is above it now,
Your Lordship.
right?
Your Lordship.
That repudiation is below it. It is a decision of the award of the ombudsman, which is to be declared as arbitrary, right?
Your
And
Lordship.
you also know, must have that we don't decide on evidence.
Your Lordship. Your Lordship.
So why a writ petition to challenge? Because you had the option of preferring a consumer complaint where you would have all the rights
Your
to
Lordship.
lead evidence
Your Lordship.
and to establish that the repudiation claim of the insurance company is against the law.
Your Lordship.
And you have the right to receive the claim amount as per the insurance policy.
Your Lordship.
So when you had would have the benefit of leading all the evidence,
Your Lordship.
right?
Your
Why
Lordship.
you have approached this court under 226, which do not decide normally disputed questions of fact.
Your Lordship.
So that part is later. First part is the award of the ombudsman.
Your Lordship.
And suppose if writ petition is rejected, end of the matter for you.
Your Lordship.
Then thereafter you cannot go for consumer,
Your Lordship.
right? And even if the writ petition is in a writ petition, you have to be extended relief. What is the maximum relief you can get?
I have no idea, Your Lordship.
You have no idea.
Your Lordship, if I may
I
start.
cannot decide your insurance claim
Your Lordship,
to the extent of rupees 19 lakh something something. Have you got the idea?
yes, Your Lordship, I got what
So
Your Lordship is
what
trying to-
relief? Suppose we find merit. We cannot give you by no stretch your insurance claim.
Your Lordship, if I may start with my submission. Your Lordship,
No,
the
first you
insurance
tell me,
ombudsman,
all submissions I'll acknowledge. But my query,
yes, Your Lordship.
first, court has the right to ask queries.
Yes, Your Lordship. Indeed. Indeed, Your Lordship.
So what maximum relief that can be granted in this writ petition? Certiorari, mandamus,
Yes, Your Lordship.
which one?
Uh,
And to what limit?
Your Lordship,
Because this video or whatever, your right, we cannot go into the genuineness of any document. Neither your permit, nor your insurance policy, nor your that thing, the other one, whatever. This page. We are not putting any stamp of approval
please, Your Lordship.
to the documents which you have submitted
Please, Your
with
Lordship.
your claim, right?
Please, Your
Similarly, we cannot decide on the veracity of the recording or whatever insurance had projected. Now, what is the maximum relief you can get under the Article 226? This is not a case which comes within the case of Olga Telis.
Please, Your
Madam,
Lordship.
I must convey to you, your case is not akin by any stretch of imagination akin to Olga Telis. So Olga Telis, we are not going to consider at any stage,
Your Lordship.
right? Where you have, yes, ABL to an extent, yes. But what is the maximum relief? Let us see your prayer.
Your Lordship,
Let us see your prayer first.
to direct the insurance ombudsman authority to adjudicate my matter, Your Lordship. They have closed the matter without even adjudicating it.
So goes well later. That is why I have put the question. Right?
Yes,
They
yes,
have
Your Lordship.
repudiated. They have
Yes, Your Lordship.
repudiated
Yes, Your
by the
Lordship.
letter dated 10/1/2023.
Your Lordship, under
Right.
Article, yes, Your Lordship. Article
Don't
220.
bring in Article 226 everywhere. It has certain limits. Right?
Indeed, Your Lordship.
Right?
Indeed, Your
Don't
Lordship.
bring Olga Tillis here.
But Your
Now,
Lordship,
this without looking into an evidence, how can we set aside this repudiation claim? This is a matter to be decided in a full-fledged proceeding where the parties are required to lead evidence.
please, Your Lordship. Your
Right?
Lordship,
That is the consumer court or civil court, not for district court.
yeah, Your
Whether
Lordship,
they had rightly repudiated the claim or not.
Your,
Now, what relief maximum you can
Your
have
Lordship,
in this AP?
direct the insurance ombudsman to adjudicate my matter, which they have closed without.
Why?
Because Your
Let us
Lordship,
see the scheme. Let us see the scheme. Let us examine the scheme of ombudsman. And what are the other decisions you have? Puttu Swami,
yes, Your Lordship.
contractual matter, Puttu Swami, insurance, insurance, that is a different jurisdiction matter. Puttu Swami, Olga Telis would not come. ABL to an extent. Let us see the scheme. Where is the
Yes.
scheme?
Your Lordship, scheme statutory duties, pardon, Your Lordship.
It is part of
Yeah.
this document.
Your Lordship, before going to the scheme of the written submission of the writ petition, may I request your lordship to please see annexure number 11, which is the impugned order, your lordship.
I have read fully.
Your lordship, it has been
Already
specifically
read.
mentioned. Your lordship, it has been specifically mentioned in the impugned award, your lordship, that this is the issues raised by the contesting parties are criminal in nature and beyond the authorities of this forum to adjudicate, your lordship. And that
Madam,
is
you
the
are not answering my question.
Your lordship, we cannot go to any forum, your lordship, since they
No,
have.
no, you are not answering my question is, now this is the 5th time I am repeating.
Please, your lordship.
Suppose you have a merit in this.
Please, your lordship.
What is the extent of relief this court can grant it? Don't expect the letter dated 10/1/2023 that comes under the umbrella of award dated 31/3/2000.
Please, your lordship.
Point of
Your lordship, if I may answer this question after break, your
Please.
lordship. Please, your lordship.
after the break.
Yes, your lordship.
Sure.
Please, your lordship, please.
Who is the ombudsman part? Insurance section. What is the ombudsman scheme? Is it part of your paper book?
Your lordship, we have not annexed any scheme of ombudsman.
The power authority and jurisdiction of the ombudsman is under a statutory scheme. Yes, Mr. Dotto,
Yeah.
Mr. Goswami?
Yes, your lordship.
His power is defined.
Yes, Lord.
He can exercise the power within that
Yes, Lord.
Statutory
Scope.
rules.
Now, where is that?
Lordship, under Rule 15, the ombudsman is required to
first
act
is-
fairly and equitably, Lordship. This is the
Where is
rule.
that scheme?
That is, I have a copy of the Rule 15, Lordship. It says, what is
What
that?
copy? Entire
in
thing?
the-
I need the entire thing. Otherwise,
I'll get it during lunch.
I don't understand otherwise.
I'll get it
My
today.
this thing is very limited.
But this draws the contours of the powers of the yellow.
Insurance scheme to pay through. I don't know. Not train. What is the year? 2017?
Yes, Lordship.
2017, that's. Can't get here. 2024. You said rule?
Rule 15, Lordship, draws how he is supposed to act fairly and equitably. That's that particular rule says. So.
But you need to address also.
I'll
looks
do it.
like-
I'll do it, Lord. He has very limited
Not
powers.
on
to
behalf
act.
of the insurance company, on the ambit and scope of. As regards the video recordings and its acceptability.
No, see, even if that part is, Lordship, given in our favor, because that.
No, accept-
What will happen is, Lordship, the dispute will still remain how much to pay. One that was
Okay,
decided.
madam.
That
At-
again.
At 2.
Yes, Lordship. All right.
Please, your lordship. Please, your lordship. Your Lordship.
Have you read the scheme?
Yes, Your Lordship.
Yes.
Your Lordship, certain statutory rules have been imposed upon the insurance company to regulate insurance. However, Your Lordship, there is no statutory rules that gives the power to the investigating officer to record a video secretly during the time of investigation, Your Lordship. My first contention is this, Your Lordship. And Your Lordship, this video has been made by a third person who does not have any statutory power to record a valid video. And therefore, Your Lordship, this video contains no credibility, Your Lordship. And Your Lordship, while filing this video, they have not complied with the mandatory certificate of Your Lordship, Section 65B of the Indian Evidence Act, Your Lordship. They have not complied with the same, and therefore, Your Lordship, the video is not considered, cannot be considered as authentic, Your Lordship. Your Lordship, the investigating officer have failed to discharge his public duty in conducting a fair and lawful investigation. And therefore, Your Lordship, my honorable and humble prayer before this honorable court is that to quash the alleged video made by the investigator, Your Lordship.
If the video recording
Yes, Your Lordship.
is not to be accepted,
Yes, Your Lordship.
suppose,
Yes,
for the
Your Lordship.
reason that it does not carry any sanctity,
Yes, Your Lordship.
then because it is not a decision, it is a decision-making process of an authority which can be looked into
Your Lordship.
in re-jurisdiction,
Your Lordship.
right?
Your Lordship.
Not the decision. Decision may be wrong, but if the process is not vulnerable, then decision may go, right?
Yes,
Even
sir.
if decision may go, whether we can adjudicate the claim made by the petitioner before the insurance,
Please, Your Lordship.
we cannot substitute, right?
Please, Your Lordship.
So what is the maximum extent this court in exercise of its jurisdiction can go?
Your Lordship, the answer to this I would like to submit is that to kindly give me the liberty to file a complaint before the consumer forum, Your Lordship.
That
With
liberty, no, we are only on the decision.
With a
Whether-
speedy trial, Your Lordship.
Madam, that option was available to you earlier.
Yes, Your
right?
Lordship. Yes, Your Lordship.
After the decision was made when?
And
Award
dated
10
31st.
10/1/2023, repudiation. And award
Yes,
was
sir.
made when?
31st of March 2023, Your Lordship.
2023.
Yes, Your Lordship.
So we are now in 2026. 3 years.
Yes, Your Lordship. The
right?
petitioner has been suffering for 2 years now. Yes, Your Lordship.
That is a matter. Yes, Mr. Goswami.
Yes, Lordship. Lordship, I entirely agree with the observations made by your Lordship. Lordship,
You entirely agree.
No, Lordship, what about what, Lordship? Two things. Lordship may give me just 2 minutes to explain my point. There are two aspects of this case, Lordship. One relates to repudiation of the claim. The other relates to non-exercise of the authority or by the rejection of the complaint
Award
made by
has
the
been, just make it precise. Award
award, Lordship.
When the complaint is not settled by way of mediation,
Yes, Lord.
the ombudsman shall pass an award
Yes, Lord.
based on the pleadings and evidence brought on record.
Yes, Lordship.
Right. Evidence brought on record.
Yes, Lordship.
So it is not bound by the strict rule of evidence,
Yes, Lordship.
but can a video recording can be termed as an evidence.
No, Lordship. That's this part what I said.
That is what, to make it short.
I agree with that. I agree with that condition. Lordship, I will not go into it because I agree with it. My point,
It has been accompanied by a certificate under Rule 65B, giving authenticity. Yes, it would have been evident.
Yes, Lordship.
Otherwise, Supreme Court has held that video recording is prone to manipulation and all sorts of.
There are shortcomings in this. I agree to
This
that.
cannot be termed as evidence.
Mhm.
Then, in re-jurisdiction, what could be the
Yes,
maximum extent we can exercise? If finding fault with the decision-making process, that
yes.
this inadmissible evidence is taken into account, we can only perhaps set it aside and relegate it
Yes.
to decide on the evidence brought on record. This cannot be, because this is the sole evidence he has taken into account,
This
which is not evidence in the eye of the law.
Yes. No,
Those
his-
strict rule is not there,
Lordship,
but this kind of
no,
evidence, video recording,
Lordship, video recording is the reason why he did not
Let
want
us
to
see.
go into it. Lordship.
that
But
is,
he has discussed the survey report and other things also in the process.
we are not going to
Yes,
substitute.
Lordship, yes, Lordship. That's what I'm
So
saying.
we
There
are not
two as-
going to,
two aspects
we are
of
not
this
in
case.
appellate forum.
Yes, Lordship. That's
If we find the decision-making process fraught with infirmities and illegalities, then we only set it aside.
Yes.
We don't go beyond that.
Yes, Lordship. I entirely agree.
That is again a matter to be considered. If he finds that still it is not to be allowed,
Yes.
he may pass an award. But at that point of time, I think they may have they will have a separate period of limitation to go for consumer complaint. At this stage, we are on the decision only,
Yes, Lordship.
award.
I agree.
What do you say, Mr. Dotto?
Now, they are claiming, my lord, I am nobody here to say anything because I am regulatory authority. Nonetheless, fallen from. I will say only thing that they have claimed 90 lakhs and the survey session is up to
10 lakhs.
No, we are not into it.
Yes. Like a Jabon.
No, we are not into it.
right.
We are not sitting as an appellate authority. We are in the supervisory and discretionary jurisdiction to looking into the decision-making process, whether the while deciding the issue, it had taken inadmissible evidence on record
That is
or not,
very good.
to that extent.
Correct.
And we find that video recording, which is not accompanied with a certificate, that cannot be looked into.
Yes.
Right. But
Yes.
if insurance company, after being relegated, produces a certificate, that is a different matter. And so far as claim and counterclaim for the exact claim amount, that is, we are not going to decide. Because these are, we cannot take this
Very, very good.
Yes, Lord.
works of invoice and investigators' invoice into account and decide that no, not 19 lakh, not 10 lakh, 15 lakh. We cannot decide.
Your lordship will not go.
We are not going into that.
Yes, Lord.
The question of evidence.
It is a matter of evidence. And he is the best authority.
Right.
And if he decides against the complainant, they can very well go to the
This is forum. Consumer forum.
and if it goes against you, you can have appropriate remedy. Insurance company.
Like insurance are generally bound by.
Binding,
the
but that is still open.
Claimants are not bound by their decision.
Yes, madam.
Your Lordship, in this case, the Honorable Court may I have the power to quash the alleged video, Your Lordship.
Oh, no. Stay within the four corners of each jurisdiction. Don't go to the jurisdiction of a civil court.
Then Your
Right.
Lordship,
Okay, we'll put it day after tomorrow. Let me see the jurisdiction of the ombudsman.
Problem.
Because
please, Your Lordship.
it is rule 13 to 17. The rules are there. So I'll have a look.
Yes,
Yep. Day after tomorrow, minute.
problem.
Please, Your Lordship, please. Please, Your Lordship.
Heard Miss H. Likidibo. NH Mazhar Bhuiyan.
IS Mazhar.
IS Mazhar Bhuiyan. Argus Sami as doctor. Is the case again, analyze the case again on 19-2 for further consideration. Okay.
Obliged.
Obliged.
Obliged, Your Lordship. Obliged.
শুনিব লাগিব ন
3 and 4.
May I please, Your Lordship? Lordship, there is some subsequent development. We need to file an appropriate application.
Affidavit in reply.
No, Lordship, we have to file an appropriate application because during the pendency of the matter, there has been some subsequent development.
Okay. Yes.
1 week time maybe.
1 week time. Okay. You are in which case?
Lordship, item number 3.
And Ms. Chaudhary? You also? Okay. Ms. M. Bora. Learned counsel for the petitioner in 3. And Ms. B. Chaudhary, learned counsel for the petitioner in 4. I have conjointly submitted that in view of subsequent developments which have taken place during the pendency of the writ petition, a need has arisen to bring such subsequent developments by way of appropriate on record by way of appropriate pleadings. Both have thus paid for 1 week time. 1 week time to file such appropriate pleadings. So, Mr.
M. Gogoi, Lordship.
M. Gogoi,
Respondent number 2.
counsel for the respondent,
Number
NRL,
2. NRL. Lord.
NRL authority. And he's there
No, he's with me.
for the respondent and NRL authorities. Has submitted that he has no patient such prayer poster in view of the above, let the cases be listed on in order to enable the petitions file the appropriate pleadings.
Obliged. Case relating to non-payment of contractual dues, Lordship.
Should work order.
No, I have not received the instruction, in fact.
Affidavit.
Lordship, I need some more time, Lordship, to file my affidavit.
You have received instruction.
No, Lordship. It's the first occasion matter has been listed, Lordship.
But first occasion, second occasion.
No, Lordship. Anyway, Lordship. Or Lordship may dispose of also, Lordship. The chief engineer may examine the case of the
Direction is there to bring your stand on affidavit.
Lordship. Then Lordship.
Heard Miss
Taylor Yanhan.
Learned counsel for the petitioner, Mr. N. Upadhyay, learned standing counsel for all the response. Mr. Upadhyay has sought for further 3 weeks time has submitted that he has not yet received the necessary instructions and has sought for further 3 weeks' time to obtain the necessary instruction and to file counter affidavit in deference to the order dated 3/12/2005. The prayer made by the out post of list the case on so and so. The respondents shall ensure that its
Lordship.
affidavit, its stand is brought on affidavit
Lordship,
before
obliged,
the next date of.
Lordship, Lordship.
16.
Obliged, Lordship.
Then 6 to 10, 4 orders.
Lordship, in this matter, we yet to receive the signed affidavit, Your Lordship. We have not yet received the signed copy of the affidavit.
Affidavit.
Yes, Your Lordship.
Ready.
It's ready. We'll send for vetting. We'll receive within a week's time, Your Lordship.
P. Hazarika, learning counsel for the petitioner is present. Different petitioners. Mr. R. Gogoi, learning counsel appearing for the respondents has submitted that the affidavit in opposition. We have the respondents is going to be filed within one
Within a
week.
week, 1 week time.
Okay, within a week's time. Yes, that's what listing of the case. After a week, post place the case on so and so. The respondents will ensure that its affidavit is filed invariably before the next date.
6.
Obliged, Lordship.
Item 11.
Where is again Somoria? Somoria, Mr. Somoria. He was absent earlier. Again, he is absent. Miss
NB Kaistha.
AB,
NB Kaistha.
M,
NB Kaistha.
and Nogam.
No, Nilakshi Kaistha.
Nogam.
Nilakshi.
And B. Casto, Learned Counsel for the applicant petitioner is present. The learned counsel for the respondent bank is found absent. Miss Udas is also there. Udas Likidiva are present. The learned counsel for the respondent bank is found absent today on call. So on the last date of listing, 28/1/2000. 26. Also, the learned counsel for the respondent bank was absent despite reflection of his name in the cause. Gusto. This is the case to come up for answer justice on next date, 13 days. Gusto, it is observed that in the event the learned counsel for the respondent bank is found absent on the next date of listing, the application will be considered on the basis of the materials on it.
6. Item 13 for hearing.
May I please, Your Lordship. Lordship, the Gauhati case, my lord, similar matters has been decided by the
Gauhati case.
Ki covered this? Ki?
Yes, my lord, admitted position, my lord. Because it's my humble submission would be, my lord, this is not covered because facts are not covered, my lord. How can that be a
If the
covered?
facts
my
are not covered, then
My lord.
cannot be covered by any other district.
Yes, my lord.
How many petitioner?
Two, my lord.
Huh?
Two.
Two.
Yes, Lord.
some public distribution. Madam Das,
My-
page 33.
Yes, my lord.
What is the reason?
Reason for my lord disorder.
For cancellation of the license?
Yes, my lord, because
Where are the reasons recorded?
yes, my lord, reasons are not my lord, categorically stated, but my lord, in his reply, my lord, he has admitted that, my lord.
Reply in the show cause notice?
My lord, yes, my lord. He has admitted, my lord.
No, where in the show cause notice?
Page 23, Annex 7.
So page 20, show cause reply should reach. Page 20, my lord.
Which paragraph you show me that he had admitted?
We received, my lord, it appear, may I read the order or my lord that
No,
particular?
no, in the show cause notice because see,
My lord,
in the show cause notice,
my lord,
you have said,
my lord.
say for example, page 20,
My lord,
whereas it appears from the report
my lord,
that Joy Kumar Hajam,
my lord.
agent under so-and-so, did not distribute NFSA rice for the month of so-and-so
My lord,
to the consumer till 8/6, though he received the said rice on 3/5.
my lord,
As per his statement,
my lord.
his son sold so-and-so quintal of rice and he purchases back from other sources in the evening.
My lord,
It is observed that the dealer intended to divert the allotted rice for personal gain
lordship,
and so-and-so so forth.
my lord.
So is there any admission in the so-called?
Yes, my lord. Reply, my lord.
Where?
Yes,
Where?
my lord. Page 23, my lord. His reply. May I read?
He- Yes. But page 33, there is nothing.
It's 33, yes, my lord.
Huh,
The
there is
reasons for,
nothing.
my lord, and
After going to the entire case history, on perusal of documentary evidence, sufficient incriminating materials are on record. What are the records? Minimum charge sheet should be there.
No.
And in similar cases, for the same region,
because my lord, here he has admitted that for 4 quintals,
no, it is not that wholly set aside.
my lord,
For not recording of regions,
my lord.
that order may be set aside, but it will be again passing a fresh speaking order.
Press order, lordship,
Right?
lordship,
Cannot be, he may have committed irregularities.
my lord.
We are not judging that.
Lordship, lordship,
But
lordship,
belief of region
my lord,
will not
Order.
sustain this order.
my lord.
And secondly, by appellate authority cannot supplement regions. It has to be from the
By
original
the
authority.
original authority, my lord.
Right.
Because he has admitted and my lord, he
And
did
then
not.
let him take into
Yes,
account. Yeah.
and other man also, my lord,
We'll delegate, it will start from the stage of
from the
passing
stage
the
of passing of the
speaking order.
deeply obliged. my lord.
Right. That is the
Deeply
only one.
obliged.
Yes, Mr.
Islam.
A.S.
Islam.
A. Islam. Okay. Two, the two petitioners have joined together to institute the present petition under Article 226 of the Constitution to assail a common order dated 6/11/2023. Passed by the respondent number, that is, Commander Sub-Divisional Officer Civil, Lakhipur, Kachar, whereby the fair price shop FPS licenses issued to the petitioners under the Assam Public Distribution of Articles Order within bracket AP 1982 within bracket the APDA order have been cancelled with immediate effect. Full stop. Para. The petitioner number 1 was a holder of an FPS license and a retailer under Messrs. Ziri Fuletal Gaon Panchayat Samabay Committee GPSS. Both. Full stop. On 8/6/2023, comma, during an inspection, comma, during inspection by Duke, on the basis of a complaint, comma, an inspection was carried out in the fair price shop of the petition number 1. Sorry, public complaint regarding non-distribution of NFSA rice. An inspection was carried out and is 14B যেটা আছে rice depots sale registers were seized. Full stop. A similar inspection was carried out in the fair price shop of the petition number 2 also on 8/6/2023. And oh sorry, go to 14. Next to 14B. Right. I go to 14 or next to 14. Just carry it out. Post of after the articles were seized and by way of executing zimmanamas of the event date, the seized articles were again given in the custody of the petitioners by the respondent number 6 on an undertaking from the petitioners that they would not dispose of the seized rice without an order of the area officer and would keep the seized articles in good only rice can you say rice seized rice articles of seized rice and would keep the seized rice in good condition. Full stop. Subsequently on 12/6/2023, the respondent number 6 filed an office letter filed an office order of event date, allowed the petitioners to distribute the seized NFSA rice to the beneficiaries with immediate effect in the interest of general consumers. Post of para. On 15/6/2023, comma, the respondent number five past orders, comma, past two orders, whereby the FPS licenses of the two petitioners were suspended with immediate effect. Full stop. Para. Para. In respect of the petitioner number 1, comma, the order of suspension dated 15/6/2023 had inter alia mentioned that it was reported that the petition number 1 did not, comma, a retailer under Ziri Fullertol GPSS did not distribute NFSA rice for the month of June 2023 to the consumers till 8/6/2023, though he received the rice on 3/5/2023. Post stop. It was mentioned that the petition number 1 intended to divert the allotted rice for personal gain, and he did not maintain stock register of allotted articles. Full stop. The petitioner number 1 had failed to hang the beneficiary list in his fair price shop, and he also failed to submit the monthly performance reports. Full stop. It was mentioned that the petition number 1 had thereby contravened the provisions of clause 6 within bracket 4 of the PDS Control Order 2001, comma, clauses 18, 20, and 21 of the APD Order 1982, and violated the clauses 3A, 4, 5, 81, and 81 of the terms and conditions of the FPS license issued under the APD Order 1982. While suspending the petition number 1 by the order dated 15/6/2023, he was also asked to show cause as to why his FPS license should not be cancelled for violation of the aforestated clauses and the terms and conditions of the FPS license. The petition number 1 was directed to file his reply to the show cause reply within a period of 10 days therefrom. Post up. Tapera. By the order of suspension dated 15/6/2023, the petitioner number 2 was informed that it was reported that he, an FPS retailer under Diri Fullertal GPSS received the NFSA rights for the month of June 2023 on 5/6/2023. Full stop. While other FPS retailers did not lifted the same in the first week of May 2023, the petitioner number 2 collected the rice from other sources on 7/6/2023. Full stop. It was mentioned that the petition number 2 intended to divert the allotted rice for personal gain. Full stop. He also did not display stock and price board in his fair price shop, and further, did not maintain stock register of the allotted quantities and did not hang the beneficiary list in the shop, apart from non-submission of monthly performance reports. Full stop. It was alleged that the petition number 2 had thereby contravened clause 6(4), page 21 of PDS so-and-so, clause so-and-so of the APD order 1982 and violated clause so-and-so. বাকিখিনি show করবো একেই। Para. On 19/6/2023, Commander respond number 5 had informed the petitioners that after distribution of the seized NFSA rights for the month of June 2023, it appeared that the petitioner number 1 had shortage of rice to the extent of 4.03 quintals, and the petitioner number 2 had shortage of 10.00 quintals of rice for distribution to the beneficiaries. Post of the petitioners were directed to arrange the said quantities of rice and hand over the same to the dealer to whom their fair price shops were tagged. Post of on receipt of the order of suspension and direction to submit so-called reply, both the petitioners had submitted their so-called replies before the respondent number 5 on 23/6/2023 and 26/3/2023 respectively. Post of in their so-called replies, the petitioners had explained the reasons regarding the alleged deficiencies mentioned in the order of suspension so-called reply, so-called notice dated 15/6/2020. Para. On 3/10/2023, comma, notices were issued to the petitioners by the respondent number 4 to attend his office on 12/10/2023 for a hearing in connection with the cases initiated against them with a further with an observation that in the event of failure to attend the personal hearing, comma, the decisions will be taken ex parte without prejudice, and with the consequence of appropriate actions under the Essential Commodities Act 1955. So, the petitioner have stated that they had attended the office of the respondent number 4 on the scheduled date of hearing. It was after personal hearing, comma, the impugned order dated 6/11/2023, impugned order, the common order dated 6/11/2023 came to be passed under the hand of the respondent number 4. Agreed by the impugned common order of cancellation, common order whereby the RPS licenses of the petitioner were cancelled. The petitioners preferred separate appeals under order (29) of the APD order 1982 before the appellate authority, that is the respondent number 3.
Some facts, my lord. They have approached the Honorable High Court, my lord, by way of filing 1489. Isn't it? My lordship will find that page 46, lordship will.
On 19/2/2024. Poster. The petitioners were accorded personal hearing by the appellate authority in terms of a direction given by this court, right?
My lord, cancellation, against the cancellation, my lord, they preferred appeal as per
That is what I am
as per
recording.
the order. Because cancellation, they have challenged. Since appeal provision was there, so that's why they were directed to preferred appeal.
Appeal was disposed lordship pursuant to order passed by this.
By this honorable court.
No. After the impugned common order of cancellation,
My lord.
you prefer writ petition or appeal?
Lordship.
That is what Ms. Das is saying.
Lordship.
Ms. Das is saying that you first prefer writ petition.
Lordship, yes, from this, my lord, this paragraph, So it is not very clear in
What I have understood,
Lordship,
that
he
is
preferred
that
appeal, but
if you see page 43, these appeals were preferred on 19 to 2024, right? And come to page 48, fourth para.
Yes.
High Court order is 15/3/2024.
Yes.
Meaning thereby
Appeal
the
was
order was subsequent.
Yes.
So they preferred appeal perhaps directly. When it was not disposed of, they preferred writ
Directed.
petition, and High Court directed
Yeah,
dispose of the
correct,
appeal.
correct.
I have
Yes,
noticed.
that is the fact, my lord.
I
Correct.
have noticed the dates.
My lord.
Thereafter, I have started
Oblige,
dictating.
oblige, my lord. I thought, my lord, that writ petition will miss.
কোনকেইটা থাকিল? On 15/3/2024, in writ petitions preferred by these two petitioners, and they appeared accordingly before the appellate authority on 3/7/2024. Pursuant to notices, dated 29/6/2024, by the appellate authority. Post op. Thereafter, by separate orders, both dated 10/7/2024, the appellate authority dismissed the appeals by upholding the decision of the licensing authority regarding cancellation of the FPS license of the two. Agreed by and dissatisfied with the order of the licensing impugned common order dated so-and-so of the licensing authority, and the orders dated 10/7/2024, passed by the appellate authority. The petition are before this post op. Heard Mr. L.R. Learned Counsel for the petitions, and Ms. Udas, Learned Additional Senior Government Advocate, Assam, for all the responses. The primary contention on behalf of the petitioners is that the licensing authority in the impugned common order dated 6/11/2023 did not assign any specific reason for cancellation of the FPS licenses of the petitioner. And as a result, the same being a non-speaking order, cannot stand the scrutiny of the appellate order having affirmed such a non-speaking order is also liable to be set aside. Having affirmed such a non-speaking order is also liable to be set aside. Sarah. The State Council has other hand, has committed that from the so-called replies submitted by the petition, it would be evident that the petitioners as FPS licenses had contravened the provisions of the contravened a number of provisions of the APDA order and the FPS licenses issued to them. First of, the natural consequences for such contravention would be suspension followed by cancellation of the FPS license. First of, the State Council has supported the decision of cancellation of the FPS license of the petitioner by the licensing authority, followed by affirmation of the said decision by the appellate authority. So I have gone through I've considered the submission for the learning council for the party to the methods from court. Full stop. The FPS, the fair price of pricing are issued under the provisions of the Assam Public Distribution of Articles Order 1982, an order made in exercise of powers conferred by Section 3 of the Essential Commodity Act 9. The petitioners were appointed dealers and they were running fair price shops on the basis of the licenses, from a license number 84 of 19 and license number 84. Both 84 wrong, something wrong. 85 of 1982-83 under Messrs. ZD Fullerton Cooperative Society, ZD Fullerton ZPSS. Para. The APDA order has contained provisions for suspension and cancellation of the licenses. First of, as per order 15 within bracket 1. If any licensee or his agent or servant or any other, as per order 15-2, no order of cancellation shall be made unless the licensee has been given reasonable opportunity or stating against the proposed cancellation. But during the pendency or in contemplation, the license can be suspended for a period not exceeding 90 days without giving the license of stating that case. On perusal, though of sorry, in the so-called notice, notices issued to the petitioners mention reference was made of a number of clauses of the PDS within bracket control order 2001, APDA, the APDA order 1982, and the terms and conditions of the FPS license issued under the APDA order 1982. First off, in the SOCOS, in the replies to the SOCOS notices, the petitioners have sought to provide explanations. First off, justifying the alleged deficiencies reported against them. First off. But on perusal of the impugned court order, dated 6/11/2023, it is found that the licensing authority, while deciding to cancel the FPS licenses of the petitioners, did not assign any specific reason for which he found the necessity to exercise the power under clause of the order, clause 15 within bracket 2 of the APDA order 1980. So, where it is an order of cancellation of a license issued under the APDA order 1982 visits the person with civil consequences. Also, an order which entails which visits a person with serious and adverse consequences must have must contain the regions wherefrom it can be known to the concerned person that the licensing authority had after due application of mine had found reasons, justified reasons for cancellation of the license. In the cases in hand, in the cases of the FPS license, it is noticed that the petitioners were operating their FPS license after being granted the license in the year 1982-1983. For operating the FPS shops, running the FPS shops since a number of decades after being granted licenses in the year 1980-19. Close stop. Yeah. The what will what will the recording of regions in the order of cancellation passed by the licensing authority is higher. Sorry, the responsibility of the obligation to record regions, the order passed by the licensing authority. The order of cancellation passed by the licensing authority is higher when the order to be passed by the licensing authority as the original authority is an appealable order. An order which affects the rights of a person requires a recording of regions, as the regions recorded would aid the appellate authority to see whether the licensing authority as the original authority had acted fairly and reasonably to the aggrieved person. The recording of regions in the order of cancellation, more particularly, when the adverse order has the possibility of impacting the person adversely, is necessary, as then only the person aggrieved can have the knowledge of the reasons as to why the order has been passed, and then only he can have a proper opportunity to demonstrate before the appellate authority that the reasons which impelled the licensing authority to pass the adverse order against him is erroneous, comma, arbitrary, comma, untenable or unjust. Full stop. Oh. আগত লিখো। আগত লিখো। আগত। মাজত থাকিব। A speaking order is one which expressly states হ'ব পালো। For states the reasons for a decision. In other words, a speaking order speaks for itself by assigning reasons behind the conclusion. Full stop. If an order is passed without giving a reason by the concerned authority, comma, more particularly, comma, when the authority is a statutory authority, then the order is a non-speaking one. Non-speaking order is one which does not provide a clear reason for its decision. Full stop. The authority exercising the statutory power must record reasons for its decisions, comma, unless such obligation is not expressly or impliedly dispensed with. Full stop. It is implicit in the principles of natural justice and fair play that an authority which has been vested with the power to decide the matter should record reasons as it is a part of fair procedure, comma, more particularly, comma, when the decision is likely to affect the person concerned. Full stop. Recording of reasons is also prima facie suggestive of conscious application of mind on the part of the authority. Full stop. The obligation to record reasons is a possible check against arbitrary action on the part of the authority invested with the statutory power to take a decision which is likely to affect the right of the person concerned. Full stop. Absence of reasons in the decision falls short. Para. Having regard to the aforesaid aspects, comma, when the impugned common order dated so and so is examined, comma, the impugned common order so and so is evidently a non-speaking order. And the same cannot stand the scrutiny of law. Full stop. As the same as violated, as the same is found to be in violation of the principles of justice. Full stop. Law is well settled that public orders publicly made, comma, in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant, comma, or of what was in his mind, comma, or what he intended. Stop. Therefore, comma, explanations sought to be provided in the affidavit in opposition. Filed by the respondent number 3 is not to be considered. First, but in view of the above obtaining fact situation, comma, the impugned common order dated so and so, passed by the licensing authority, and consequently, comma, the orders, comma, dated so and so, passed by the appellate authority, are found unsustainable, are found not sustainable in law, and the same are liable to be set aside and thus, full stop, it is accordingly ordered. Full stop. Para. With the above orders being set aside and passed, comma, the licensed authority has to proceed now from the stage of consideration of the so-called replies submitted by the and to pass a speaking order in respect of the cases of both the petitioners. Full stop. After consideration, comma, the licensing authority shall pass the speaking orders taking into account the provisions of the control order given, APD order 1982 and the terms and conditions on its own merits and in accordance with law. Full stop. In as the proceeding was initiated, as the proceedings against the petitioners were initiated as far back as on 15/6/2023, comma, the licensing authority shall bring the proceedings in case of both the petition to a logical conclusion within a period of how much? Only to pass the order.
Lordship may consider.
1 month?
My lord,
Within a period of 1
the
month.
date of receipt.
From the date of submission of a certified copy of this order by the petitioners at his office.
My lord.
That is, I think, who passed the common order?
My lord, as DO, my lord. Subdivisional
order?
officer. Page 33, my lord.
Ah.
Subdivisional officer.
Is the licensing authority?
Lordship, 1 month is
Huh?
sufficient, my lord. Lord.
Right. With the above, with the observations made and the direction given, the writ petition is disposed of.
my lord,
There shall be no order as to cost.
deeply obliged.
May I pray for one thing during pendency of the proceeding, their license may.
My lord, 1 month.
1 month. But
My lord,
on its own merits,
my lord.
then you'll have another opportunity of filing an appeal. Then another writ petition. Okay.
I've seen, my lord, in the entire GP, my lord, that all the shop license holders are, my lord, so cost 5, my lord. The meaning thereby in that area, my lord, this is happening, my lord. So that's why, my lord, on the other day, though it is off the record, I have seen in the TV, one person